Your haircut in a while, huh?
Nice to see you, sir.
Sir, do you need to get your hair cut over at the jail?
Yes, sir.
Okay, we'll help you with that, okay?
Yes, sir.
Get you, yeah.
Yes, sir. Lieutenant Morgan,
All right.
I'm sorry. You're gonna do it. as soon as you're
Okay.
back.
You are Xavier Aguiar,
Yes, sir.
and you're charged here in this offense with assault on a public servant, sir. And Dr. Edgar Pond evaluated you last year for competency and declared you to be competent. And today is the trial day.
Yes, sir.
And so we're going to get you dressed and get you ready for trial, okay?
Okay.
All right, you see Joel here, Vasquez? He's your lawyer, you know that. All right, you want to talk to him before the trial, maybe?
No, sir.
You ready to go?
Yes, sir.
Yeah, okay, you've studied on your own.
I have, sir. Yes.
All right. Do you understand completely what you're charged with here, though? You're charged with a third-degree felony of aggravated, I'm sorry, assault on a public servant, which is a third-degree felony. But the indictment goes on to allege that before you committed that third-degree felony, you were convicted in 2020 in Montgomery County for the second-degree felony of illegal possession of a controlled substance. Do you recall that event?
Yes, sir.
After that was filed. Oh, I'm sorry. That was December 20th, and that cause number, and it's 20-02-01978, which is the way they numbered things in Montgomery County. After that conviction was final, paragraph 3 of this indictment alleges that you thereafter committed another illegal possession of a controlled substance, a second-degree felony, and you were convicted of that on June 20th of 2023, also in the same 359th District Court in Montgomery County, Texas. You remember that event happening?
Yes, sir.
After that was final, it is alleged in paragraph 1 that you then commit the offense alleged in paragraph 1, a third-degree felony of aggravated assault of a public servant. If you were found guilty of this this assault on a public servant, rather the third-degree felony, and it says that you caused bodily injury to the public servant by striking him in the face with your hand. And he was apparently, I guess he was a jail security official. So he must have been a jailer. If you were found guilty of that crime, if it were found true that you have these prior convictions out of Montgomery County that of illegal possession of a controlled substance, then you were looking at what we call habitual felon status. Your punishment range would be no less than 25 years in prison, a minimum of 25 years in prison to life in prison. It's the most serious type of punishment other than, I guess, capital punishment. So do you understand what you're facing here, sir?
Yes, sir.
All right. Have you talked to Mr. Vasquez about whether that could be resolved without a trial or not? Because that's what we're here for. We're going to try this case unless y'all can reach an agreement with the DA's office. Have you thought about that? Why don't you talk to him and just find out what the options are, and then we're going to do whatever you want to do, okay?
Yes, sir.
Yeah,
Okay.
go ahead.
All right, I'll go ahead and put it on the record that I was going to waive his priors and agree to a 5-year sentence. As far as
All right,
that's the
talk to
plea
him.
bargain agreement.
Y'all go back and talk, okay, Xavier?
Yes, sir.
And so what, do you understand what he's saying? It's going from, if we go to the jury, you're looking at a minimum of 25 years imprisonment if found guilty. And they're offering 5 years with credit for time you have served in custody in regards to this, which I'm not going to influence you, but that's a most generous offer. But at the end of the day, it's your choice. Whatever you do, we're going to take that route, okay?
Yes, sir.
All right, talk to Joel and come back and let me know what y'all do because y'all are up here for trial. Okay.
Thank you.
Thank you. Do I have any pleas in the queue?
You should, you know,
Yeah.
you've been cited, so.
And then couldn't even find the family, and then they were on the other side, we were on the left, and then got to the right, and then we had to go, you know, it's, they change so fast. And those, that's such a special time to see them. And look, here's the deal, I couldn't, there are like 3 or 4 kids up there that look the same. You know, they're in the, and it happens, they're little children, and then they put on makeup. They got the makeup, and they're 7, 8 years old, and they all look the same when all the makeup's on. Well, I was asking Muskie, which one's ours? Well, but those are special. They change so fast, you know, actually, you know. All right. We now call 24 CR 341, the state of Texas versus Logan Kyle Birdsong. You are Mr. Birdsong, present, with your attorney, Mr. Walker, a great judge, and then the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in sum?
Yes, sir.
Let's see. Looks like we got a lesser included going here, right?
Yes, sir. Seems to be my day for it.
Well, you're probably going to be a popular guy then, if this is your day for lesser included.
Yeah,
That tends to get the attention of.
just happens to fall that way on the docket this time.
Okay, we're going to do like the previous case, second degree felony.
Yes, sir.
And again, does the defendant waive a formal reading of this indictment? We can proceed in murder.
He does.
The murder indictment and proceed in summary.
Yes, sir.
In summary, sir, this indictment alleges that on or about December 7th, 2023 in Jefferson County, Texas, this indictment states that you committed the first degree felony of murder. Do you understand what you are charged with?
Yes.
Okay. An agreement has been reached in your case where you would be pleading guilty to the second degree felony, the lesser included offense of manslaughter under this indictment. Is that your understanding of the plan?
Yes, sir.
Under section 19.04 of the Texas Penal Code, it provides the elements of the crime of manslaughter. A person commits an offense if he recklessly causes the death of an individual, and an offense under this section is a felony of the second degree. Is that your understanding of what we are doing here today, sir?
Yes, sir.
If convicted of a second degree felony, you face no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand, sir?
Yes, sir.
An agreement has been reached in your case where you would be pleading guilty, but not found guilty. You would be placed on deferred or unadjudicated probation, which can be up to 10 years in length, fined $500. And is there any restitution here
No.
in this?
No.
Okay. Is that there would be terms and conditions of probation which are normal and customary for the circumstances of this case? Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this second degree felony of manslaughter, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence,
No objection.
and without objection, it's admitted. Among other things, this states You are mentally competent to enter your guilty plea. It's freely and voluntarily made. You understand what you're charged with. The indictment has been read to you. Are you ready? You were guilty of any lesser included offenses, as well as you could be prosecuted for the indicted offense. Manslaughter is a lesser included offense of murder that you have pleaded guilty to in this case. And you were totally satisfied with the representation provided by your lawyer, and you were giving up all rights to a trial and moving forward in this manner. And is this what you want to do? All right. State's Exhibit 1 is tendered into evidence without objection. It is admitted. Pre-sentence report is waived.
Yes, sir.
What I'm going to do, though, is order a post-sentence report. Place him on probation here, get a post-sentence report come back, and then we'll figure out what terms and conditions of probation are in the best interest of all concerned. All right. If nothing further, I'm going to find you, sir, have pleaded guilty to this lesser included second-degree felony of manslaughter voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. And even though there's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this manslaughter lesser included offense, I am following this agreement. You will be placed on deferred or unadjudicated probation, not found guilty, so long as you follow these terms and conditions of probation. Make sure you do. We're going to talk to the probation officer, and you get squared here with the plan for the post-sentence investigation and report. Please make sure you follow these terms and conditions. And look, there's 35 of them, but I always tell people about 30 of them, all of us have to follow. So. Probation officer will review with you all of this. There's a premium on making sure that you follow these terms and conditions of probation, because if you failed, your probation can be revoked. You can then be found guilty and sentenced up to 20 years in prison. Do you understand?
Yes, sir.